Well, hello, everybody, and thanks for joining us here at Hudson Institute. We hope to have a very live audience, and I appreciate everybody joining us online as well. I'm excited to be here and to have Hudson Institute host this. My name's Brigham McCown. I'm a senior fellow here and director of the American Initiative on Energy Security. And I'm honored to be joined by such a distinguished panel this morning. And so let me introduce each one of them. Have a rather lengthy bio due to your success, but I'm going to hopefully not butcher it as I have tried to exercise editorial review and fit it into the space allotted. Drew Bond is a serial entrepreneur, public policy thought leader. You're the co-founder of C3 Solutions and the Conservative Coalition for Climate Solutions. It's an educational nonprofit based here in Washington, D.C. But you're also co-founder of Powerfield Energy, a scalable solar energy installation company. Do I have that right?
Yeah, you got it right.
Perfect. You served as the Director of Technology for Commercialization at the Energy Department under George W. Bush, and then Vice President for Technology and Commercialization of Public Policy at Battelle, Chief of Staff at the Heritage Foundation, and Chief of Staff to Denise Bode of Oklahoma, and also the Oklahoma Corporation Commission, and Legislative Assistant to former U.S. Senator Don Nichols. Thank you for joining us.
My pleasure.
Phil, you're the Office Managing Partner at Shook here in Washington, D.C., and the Public Policy Practice Group Co-Chair. You have over 25 years of experience and a leading expert in high-stakes liability and public policy issues, and your work has shaped key legal precedents, and you're a significant voice in the legal and public policy circles. Thank you for joining us today.
Thank you.
Professor Donald, is it Koshin? Koshin, sorry. Professor Donald Koshin is Professor of Law and Executive Director of the Law and Economics Center at George Mason University's Scalia Law School. You're also a non-resident scholar at the Center for the Constitution at Georgetown University Law Center, and you write extensively on climate change litigation, and your scholarship focuses on area of law, tort law, constitutional law, administrative law, local governing law, natural resources, environmental, and law and economics. Thank you so much for joining us today. In recent years, 30-plus states and municipalities have filed lawsuits against energy companies under state public nuisance doctrines and consumer protection laws seeking damages for the alleged effects of climate change. These climate lawsuits, including third-party lawsuits by youth groups, particularly Montana and Hawaii come to mind, have attracted the attention of the U.S. Supreme Court. And whether or not these claims of damages may be protected by or precluded by the Constitution, various acts passed by Congress, and regulations. In particular, we think of a lot of environmental laws that come to mind, including the Clean Air Act. In early June, the U.S. Supreme Court invited the Justice Department's Solicitor General to file a brief in a case expressing the views of the United States. The outcome, obviously, of these lawsuits is quite significant on legal, foreign policy, domestic policy, congressional and public governance, as well as potential implications for innovation-related fields. That's a lot to cover in about an hour, so should we get started?
Absolutely.
I'll get to as many questions as I can, and I'd like to share some interaction. And for people in the audience, we would love to have your views and questions as well. So we'll leave some time for Q&As before we get finished here in a little over an hour. I guess my first question goes to Donald. How does our constitutional system restrict production of legislation, meaning sometimes we don't get laws passed that some people would like, or what we commonly refer to as gridlock in DC. Or stated more simply, why is gridlock a good thing?
Sure, absolutely. Well, thank you very much for having me, and thank you to all of you for being with us. These cases are critically important because they do test this idea of our separation of powers and the structure and institutions, as well as the normal processes for generating legal rules, the normal processes for generating those things which are going to restrict individual behavior, and also critically, I think, for our topic today, the normal processes that help to guide balanced energy policy and other decisions. So one of the things that we entrust through the Constitution is the legislative branch to do the legislating. But at the same time, as you mentioned, right, we don't expect legislation to be easy. And so in the federal system, for example, we have bicameralism and presentment. We have other veto points, choke points as they're sometimes called, that make legislating difficult. Legislating is intentionally difficult for a variety of reasons. One is it forces deliberation. We get better policies if it's not easy to generate legislation, but instead requires deliberative bodies to debate, to get inputs on ways to balance competing interests, such as generating regulatory restrictions on activity to benefit the climate at the same time, and fostering an environment in which innovation can occur to help the climate. Ways in which we balance sort of the need for redress from certain harms with other policies in energy or in the energy space or elsewhere. So with bicameralism and presentment, for example, it adds costs. That is, you have to get a bill through the House, then you have to get it through the Senate, then you need to get it signed by the president, and if the president vetoes it, then you need to go through a 2/3 majority to overcome it. It's meant to be very difficult. And so gridlock is, in fact, good. It is part of the design. One of the things that you see in the climate change litigation is a frustration with this, and it's labeled as dysfunction, when indeed much of what is labeled as dysfunction is the normal processes that are meant to make legislation hard. Our founders understood that the production of legislation was intentionally meant to be low because every bit of legislation is necessarily going to be controlling. And so we want, if we're going to go to that level of sort of a coercive command and or other ways in which the government gets interfering with normal market processes and private ordering and private behavior, we want it to be well thought out. And so in that sense, our Constitution leaves it to the legislative branch, which has these processes which are expensive in order to make legislation rare. When you start overcoming those barriers by saying, oh, the courts can just do what the legislature isn't doing, or that the courts can fill in so-called gaps, that becomes problematic. And I'll just say one last thing about those legislative gaps, is that there are, because production of legislation is intentionally meant to be low, there are a variety of areas which are meant to never be legislated. And when Congress chooses not to or is incapable of reaching a consensus to have a legislative solution to something, it doesn't mean in our constitutional system that the courts have a gap to fill. It doesn't mean that congressional silence, for example, it means that there's a space for litigants or for the courts to fill that space. Indeed, it may be intentional to leave the marketplace or other areas free to innovate and find different ways to achieve some social outcomes.
Okay. And Drew, let me move to you. And by the way, Professor, I did you disservice. I was supposed to give each of you opening remarks, and I totally skipped over that. So let me fix it this way. Drew, if you have opening remarks or anything you would like to talk about from a 30,000-foot view, go ahead. And then my question for you is, how does this litigation negatively impact public policy decision-making? And then I'll come over your way next.
So the question is
Oh, for Phil.
For
Okay.
Drew. Yep.
Phil.
For Drew. For you.
For me.
Yes.
So the question is, how does this negatively impact policy?
How does all this litigation negatively impact policy? But feel free if you have some opening thoughts on the subject first.
Well, I mean, I think, Donald said it well. I think this idea that, litigation, that we need more legislation, that we need more litigation in order to solve the question, the challenge at hand, which is climate change, is just a false way of thinking. Our organization, C3 Solutions, was founded on the premise that you need more economic freedom, not less, in order to innovate more, in order to solve the climate challenge. And so what we know from experience, and we know from the data, and we know from history, and we've now published, our organization has published a report 3 years running called Free Economies Are Clean Economies. And this is a report where we take data from the Index of Economic Freedom from the Heritage Foundation and a lot of other indices around the world, and the Environmental Performance Index from Yale University and a lot of other indices. But those are sort of the two nameplates that stick out. You know, you've sort of got the right and the left. And when you correlate the data around economic freedom and environment, what do you find? You find that economies that are free are twice as clean as economies that are unfree. And this is not, you know, our bias. This is what history proves out. And so we know from history, we know from, you know, experience that communism is not good for the environment, that dictatorships are not good for the environment, that socialism is not good for the environment. So this is counter-narrative, but reality, it is the truth to what we're hearing oftentimes in the media, and oftentimes what young people are hearing when they're experiencing what's now called climate anxiety. This idea that the sky's going to fall because of climate, therefore the government must step in and fix our problems. I think what the data shows is quite the contrary. And I think to Donald's point, this idea that the government or the court should get sort of involved in stepping in, filling in the gaps is quite dangerous. I mean, one of the things that we talk about, you know, climate change can be a very bad thing. And so we need to address that with good policy, not bad policy. There is such a thing, of course, of bad policy, bad climate policy. And I think too often I've heard, certainly not long ago, this idea that like, oh, we just wish we could be more like China because China can just make decisions and make it happen. Well, how is being more like China going to fix the environment when China actually is oppressing its people? We are, you know, you look at their economy in terms of how they deal with child labor, and then while they're out, you know, cutting ribbons on the climate, they're also building coal-fired power plants week in and week out. So I think it's just really critical that we have this discussion around the real trade-offs of climate solutions and the fact that litigation is not what we need more of. It is simply innovation.
Okay. And Phil, sort of the same question to you now is how do you see these lawsuits as being counterproductive?
Sure. Well, first of all, thank you again for having us. This is great, and it's good to see all of you in the room and obviously those online. I would do work with the Manufacturers Accountability Project, which is under the auspices of the National Association of Manufacturers. And the reason we're out talking about these kinds of things is because we're concerned from the manufacturer's perspective that when you have local governments suing private sector companies like manufacturers to subject them to liability for what are really social or political issues, it doesn't help solve problems, and it ends up taxing and making things more expensive for people in a way that's not helpful. Climate is just one of those examples. We've seen a lot of them. This is a situation where you know, electrification has been probably one of the greatest human health and advances over the past 150 years, the ability to refrigerate and turn on lights and do all the things that, you know, help make medicines, that help do everything that we have come to understand as our modern life, you know, is something that has been hugely beneficial to society. And, you know, and the use of energy products has been, you know, is essential for us. We, you know, from driving our cars to heating our homes to turning on our lights, governments use it, they require it. But we also have to figure out how we're going to do all of that in a way that's sustainable for the people and for the planet. And that's the challenge, I think, that Drew was talking about. It's not figuring out how to creatively file lawsuits, which we're seeing now. It's about figuring out how to innovate ways so that we can manage our energy production and use on this planet in a way that's sustainable. The problem with this lawsuit, and it's kind of funny, you go back, the climate litigation has been around for 20 years. Most people are focusing on the last say 8, 9 years of the litigation. But going back to 2004, you had AEP versus Connecticut, which went all the way up to the Supreme Court. And back then, the people behind the litigation freely admitted this was about, as Donald said, their frustration with Congress, their frustration that their agendas for how they wanted to solve this issue weren't being adopted by Congress. And I think there's a lot of people from a lot of different sides of every issue that get frustrated by Congress and by the inaction and the gridlock and all that. And if all of a sudden we say, okay, if you can't get your way in Congress, just go to the court and just sue somebody, even if it's not their problem, even if it's not their fault, even if they didn't cause the issue, but somehow they're involved in that, producing that product or whatever it is, beneficial conduct, just go sue them and try to get the courts to do what you couldn't get done in Congress. Our system of government would just collapse on itself, because that's not the way that we make policy in this country. And so from and today, the people bringing the litigation say, oh no, we're not trying to do that. We're not trying to regulate. We're not trying to do any of that. We just need money for local communities. But what the Second Circuit and other courts have said is no, the effect of this litigation is to regulate. And that's why this has become hugely political and hugely controversial, and frankly, why we're having this kind of conversation today.
Okay. And Donald, traditionally, haven't the courts avoided or wanted to avoid political questions? And then second part of that, well, why is this, how is this separate from tobacco litigation or a public nuisance claim, which some people have talked about? Why do these lawsuits not fit into those blocks, in your opinion? Or do they?
Well, I mean, those are the blocks where they're trying to find analogies, and I think they're doing a poor job of that. So let me get to that. So yes, courts are meant to resolve real disputes, and they're meant to resolve disputes between a party who is wronged and a party who has done some kind of wrong. And so traditionally, courts also are constrained in how they can define and the scope of the wrongs that can be recognized, including being restrained by retroactivity, anti-retroactivity principles and due process. So courts, don't like changing the rules of the game. They are subject to rule of law constraints, and so those folks who have brought us the wonderful developments across the years in the energy space and innovation are now being told that activities that were entirely lawful at one point in the past now can be found liable for those things which were not only lawful but in many ways encouraged by both the consumers as well as by governments to do these activities in the first place. So courts traditionally say, look, one of the reasons why we're not involved in policymaking is because we are here to redress wrongs, not to create rules which are going to have both prospective and potentially retrospective effects in a way in which someone gets punished through liability for acts that were entirely legal at the time they did it. So the non-retroactivity principle and the due process and rule of law values that normally say, look, you need to be able to predict what your liabilities are, and therefore you need to be able to assume that if you are engaging in lawful behavior, you will not someday, decades in the future, be told that you are responsible for payments for the lawful activity. Courts are guardians of that principle, and when you start disrupting those rule of law principles, it actually makes it harder to innovate in spaces because people are now worried. I think I can do this, but what is my liability three decades from now if our information changes or our knowledge changes or just preferences change in society? Am I going to get punished for that? So it actually stymies innovation to have a court system which is involved in this kind of retroactive responsibility and blame for activities that we all are benefiting from and encourage. So that's sort of the first space. The second is that, yes, courts are there to say what the law is, not to say what the law should be, not to create rules, not to expand over time. Now, many of these lawsuits are proceeding on common law theories, including common law theories of public nuisance, or they're proceeding under consumer protection statutes or otherwise. But let's start with the common law. The courts have in the past recognized a common law tort of public nuisance, but it was highly contained. The prototypical situation is that you drive your car in a public way and you leave your car in the middle of the way and people can't get to work. All right, and so who should be responsible for the losses to society as a result of people not being able to get to work because you just left your car in the middle of the road and didn't take responsibility for taking it away after your car broke down. That was the kind of thing that courts recognized, and back then it was a buggy, right, or something else, but court recognized that as sort of what a public nuisance is about. Normally, as well, it had to be the government who would bring that suit, not sort of private individuals, and so it was a very limited, contained cause of action. What happened is that it's written, on its face looks relatively broad. It is sort of the interference with the public rights. And so what we did was see a manipulation of what constitutes a public right, or at least that's what the plaintiffs' attorneys got together and decided, let's sort of manipulate and sort of bastardize this common law tort in a way that will be beneficial to us. And in fact, they did it quite strategically. They all get together in a conference, in La Jolla, California, and decide how are we going to generate these kinds of lawsuits, and how can we use the courts to do what we're not able to accomplish through legislatures. And so it was a very intentional, way to try to convince the courts to let down their normal guard and expand these theories. So yes, courts should not be in the business of expanding even there. This idea that the common law evolves is we can talk more, I don't want to go too long on that, but the idea that the common law evolves, that is a rhetorical phrase that is sometimes used in past common law cases, but it doesn't mean that it gives judges the power to make law. It simply means that if you see a buggy blocking a road, when we now have cars blocking roads, right? The common law can evolve to say that, but it can't mean that it goes from a buggy in a road to, if there's a public health crisis of any kind, the courts get involved and call it a public nuisance that allows for both local municipalities and private individuals to sue on the basis of this claim.
Okay. Anybody?
Yeah, so I want to touch on this because I'm not a lawyer, full disclosure, but I look at what the legal climate activists are trying to do and drawing a correlation between the tobacco industry and, quote, big oil. And on its face, it just doesn't make sense. This idea that, I guess my question would be, who has ever smoked a cigarette and as a result risen out of poverty, right? Energy, however, is quite different. Now, you can argue about which form of energy is cleaner, and they certainly all have trade-offs, but energy helps rise people out of poverty. You give women in Africa the opportunity to move from wood-burning stove and in their hut and literally to a propane stove, and now their lives have changed. They're not breathing in that smoke. They're not having to go out and collect wood, which is actually a dangerous thing to do for multiple reasons. But you can also use just any other, pick your culture, pick your location, pick your example. Energy helps people rise out of poverty. Cigarettes don't. So this idea that tobacco industry is the same as big oil is just false.
Okay.
And I'll just add one thing to that. When you rise out of poverty, you actually live longer, and it's beneficial to everyone, right? So the idea is that it's not you are finding ways that you are enhancing human flourishing. You are also enhancing human health. You are enhancing the society by doing all these activities.
One of the points that Donald was making before about sort of the inability of the courts to step in and deal with this kind of issue, it's very interesting. Right now, one of the key issues in this litigation is whether Hawaii or Hoboken, New Jersey, or Baltimore, Maryland can say, we think the promotion and sale of these fuels around the world is illegal, is unlawful, and therefore you should have to pay us damages here in Honolulu or Hoboken or Baltimore. And you now have 20 or 19 states rising up and saying, whoa, you can't say what's legal or illegal or unlawful or lawful in our state or in other countries. You can only control what happens in Honolulu, what happens in Baltimore, what's happened in Hoboken. And so, and some courts have started to hold that. You had the Delaware courts say, whoa, you can only sue in Delaware for things that happen in Delaware. Baltimore judge said, no, these are not state law issues. These are not things that Maryland law can determine if it happens outside of this area. And so that's a lot of the friction that's going on right now, and some of the constitutional friction, and that we have some states pitted against other states, and why these kinds of broader political and social issues are really not meet for state law governance.
You know, is an interesting follow-up to that. So let's take the Hawaii case where youth had sued. I'm going to call it a friendly suit against the state of Hawaii, and then magically there was a settlement where the state transportation department decided that they would move toward carbon neutrality, and principally through moving to EVs. Have any of you followed that suit? Was that a real suit, or was that a sue and settle type of suit? And was that going to happen anyway? Because I know, just real quickly, we've talked about a lot of corporations, companies making these net zero privileges. I used to be a CEO. It'd be very easy for me to have said, oh, our company's going to be net zero by 2040, 2030, 2050. I'm not going to be there by then. And so it seems like people are making these promises without any thought of how they're actually going to do it, and that there's a little bit of smoke and mirrors behind the scenes of all this happening. This is not just an organic come out of the woodwork effort. What are your thoughts on Hawaii and or Montana, for that matter?
Well, so Hawaii is an interesting example. I mean, in 2007 and 2008, served under George W. Bush at the Department of Energy. One of the initiatives that I led under a guy named Andy Karsner was the Hawaii Clean Energy Initiative. Now, the Hawaii Clean Energy Initiative was launched partially to address the issue of climate and the changing climate, but also partially, and I would say more substantially, because of energy security concerns. If you look at the state of Hawaii, basically it's prior to the Hawaii Clean Energy Initiative, the state of Hawaii was run and primarily on diesel fuel. And so you could draw a line between Hawaii and the West Coast and see a long chain of diesel ships carrying diesel. And so from an energy security perspective, you look at that and think, okay, that's a major national security issue, right? We've got Hawaii way out in the Pacific. We've got this long line of ships that are carrying fuel to Hawaii, and Hawaii had something less than like 30 days of fuel at any given time on hand. Major national security issue. So I think to your point, Hawaii was already on a path to diversify its energy resources for various reasons: energy security, environmental, and climate. And so I think this idea that like the lawsuit came along and suddenly fixed it is just probably not the right way to think about it.
Okay. Thoughts from?
So one of the things that's happening in these cases is an extreme power grab on the part of the judiciary from the elected branches, and I think that's the real concern with these kinds of cases. So you have certain states that do have constitutional provisions about the protection of the environment or a right to a clean environment. Those are largely meant to be aspirational and to guide the legislature in goals that the state has set. And so if the state has indeed set those, and the executive and the legislature feel that they have some kind of obligation to meet those constitutional commands, then that is one thing. But for the most part, if you look at the actual constitutional history, it was not meant to create a cognizable right in the courts. And indeed, if it were to make a cognizable right in the courts, this kind of positive right, this affirmative right to something like the right to a clean environment, it would fundamentally change the institutional structures within the states, and certainly if anything like that were to happen in the federal government the same way. And the reason is as follows, right? If the courts can enforce some kind of nebulous affirmative right to a clean environment in these things, and litigants can come and claim that there's some violation by the failure of the legislature or executive to act, then the court can come in and compel legislative or executive action. They can actually force elected branches who have limited resources to use those limited resources for particularized things. And that immediately puts the courts into making policy judgments and policy decisions, including between scarce resources, how to expend those scarce resources. A governor who is not sympathetic in a state, right, who doesn't want to sort of go along with one of these settlements, may very well want to spend their money on, on roads that are going to allow for kids to get better to school, or more money into the schools, or whatever it might be. But if the courts can come in and say, no, I'm sorry, even though you only have $10 million, you have to spend all $10 million for these plaintiffs in this lawsuit, then the courts are dictating how the entire state's funding is being used, right? And or the only other way around that is the courts are forcing the legislatures to impose a much higher tax in order to get the revenues that they would need, which means it's a tax on the entire citizens in the states. That was never going to be something intended, whether it be in a constitutional amendment or something contrived in an interpretation by the courts in these states. And that's precisely what the Ninth Circuit saw in the Juliana case. And that is that courts are not meant to actually have the ability to enforce these rights, and it's filtered through the process of needing to show injury in fact, needing to show traceability and causation, and then having redressability. And so there are, these cases, these kids' climate cases and the constitutional cases in Hawaii, Montana, and elsewhere fail on every one of these counts, right? But one of the key ones that they fail on is in redressability. And the reason why it fails redressability is because the courts do not have the power to grant the remedy that is being requested, the remedy being requested to force the elected branches to expend scarce resources on a particularized policy outcome. Mm-hmm. And note that, as you mentioned, if you do constitutionalize this, then you get out of this discretion of a CEO or a governor or someone else saying, oh yes, I'll do that, and then deciding along the way how best to actually fulfill or not fulfill that promise, or to give a false promise. Because now the courts have said, no, we are commanding you to do this, which means the courts are injecting themselves forever into that process, because it gives these litigants the power to come back and say, they didn't do what you ordered them to do, now go order them to do it again. How they actually enforce those judgments is difficult for me to understand, but it is a command that the courts are now making upon the legislatures. And that was, from a separation of power standpoint, whether you're talking about separation of powers under state constitutional law or federal constitutional law, that was never the that was never the design that we have put into those constitutional institutions, and it really, if as I mentioned, it is this lack of redressability that the courts don't have the power to do this that make these cases, or should make these cases, fail.
The Ninth Circuit opinion, I think, really put a fine point on this, but it really talks about the political nature of all of these decisions, right? I mean, and the political nature, frankly, of all the litigations that are out there, whether it's the public trust cases that you're talking about, the cases against the companies, you have cases against the United States and other industrialized countries by countries that aren't as industrialized. Everybody's trying to out there to sue somebody over this issue, as opposed to dealing with the issue in kind of a real
way, right?
But in any kind of real and sustainable and material way. And so, if you look at even the litigation against the private sector, it's each one of these lawsuits names different combinations of energy companies. Sometimes it's just one or two, sometimes it's 10, sometimes it's 30, sometimes it's just the producer, sometimes it's gas stations because they want to keep it in state court, so they sue someone local, and they allege some sort of grand conspiracy or whatever it is in order to try to have some legal theory upon which they can go forward on. But it's not, again, Hoboken or Baltimore or Honolulu's decision to say, who do we want to blame for this? What 2 or 5 or 10 or 30 entities do we think should be blamed, right? And because inherently these are political decisions, very much the way Donald's talking about it, that need to be decided. How are we going to meaningfully address climate change? How are we going to try to reduce emissions? How are we going to mitigate the impacts of climate change all around the country? These are inherently public policy decisions because they affect affordability, how much people have to pay at the pump or pay in electric bills. It affects our energy security, our national security, things that you guys have talked about. these are much broader issues, and it's frankly what the Supreme Court said in 2011 when it decided AEP versus Connecticut. It said these are legislative national issues that need that, and it's a good thing, they said, that we have a federal agency, an EPA, kind of overseeing all of this, because we can't have courts making these decisions on an ad hoc basis, depending on which companies were sued by that one locality, or if it's citizens suing the a state, or it's government suing other governments. We need a national cohesive response to this, and can't just have this done piecemeal.
So do you think, and I want to give you time to respond if you wish to, but do you think, or either of you, any three of you, think that these type of lawsuits are actually hindering a national plan for the energy transition, to address climate change, decarbonization, whatever label you want to put on it? Are these actually counterproductive to that effort, and why?
I think they certainly are. One reason is because if you think about what Phil is saying here, right, comparative institutional competency, we don't expect judges to actually know about the science of climate change, or have the capacity to decide among all of the different priorities and preferences that we might have as a society in terms of affordable goods, or in terms of energy innovation, or in terms of where we want to decide to balance things. Judges are just simply incapable of doing that. And so when they start to muck around in that space, they are undoubtedly going to get things wrong.
Because when you say they're incapable, let me interrupt, sorry for interrupting, but you mean because they are not experts in that area, they're out of their core competency, out of their wheelhouse? What do you mean by that?
I think all of those, right? They are not experts in the area. They're not able to command experts in the area. They're not able to say, okay, I would like to hear now from a variety of different interest groups as to what the best policy is to set here in order to balance things. They're limited by the kinds of evidence that can be introduced into a particular case, right? So if they're going to announce a liability that's going to fundamentally change behavior, or address liability, or address costs, assess costs to companies, they can't bring in all the information they would even need. So let's assume that they actually are somehow so wise that that if they had enough information, we could entrust them with decisions, which I don't want to do. But even if you could assume that, the court system is just simply incapable of gathering the information and expertise necessary to make those decisions on a balanced level and to hear from all interest groups. They're hearing instead from only two, that is the plaintiff and the defendant in a particular case. And so the system just isn't set up for that at all. So that, in that sense, once the courts start making these judgments and are controlling individual behavior as a result, right? Prospectively, people are going to change based on the liability that they have. And then retrospectively, they're going to have to, if they have liabilities and costs, they're going to have to change how they behave. That's going to necessarily constrict private behavior in a way that perhaps the legislatures wouldn't have wanted done, and therefore it does restrict this. The second point is that the unpredictability and instability that it injects into the system as to what your actual costs of production and innovation are fundamentally changes the calculus that an entrepreneur can make in any particular space. And that's not only going to be entrepreneurs in sort of the energy space, but it's going to be those in the alternative energy space too, who don't know what their liabilities are going to come in, or those who are going to help help find the solutions to this crisis. I think there's a lot that my fellow panelists can add, so I'll just say the last thing, which is this has geopolitical interference as well, because especially when you start commanding outcomes from the cases that you were discussing before, in which they're against a governmental entity and saying government hasn't done enough and we're now going to allow the courts to compel government to do more, that may in fact disrupt the ability for the elected branches to engage in geopolitical bargaining that otherwise might strike deals as to what the appropriate balance of activities should be between nations. And so once the courts start getting involved in that, they're handcuffing some of the choices and discretion that the elected branches have.
One of the things that the people bringing behind this litigation talk about is trying to get these energy products through this litigation to incorporate their true cost, right? So if they think there's these externalities of energy, then this litigation is to try to force. But they're only, again, suing a select number of companies, and generally American companies and Western European companies, that are engaged in these efforts. So what you're going to end up doing is putting this tax or this penalty on those companies, but yet the companies, in Saudi Arabia, the state-run energy companies there, or Russia or China, they're not subject to any of this litigation, and so they're not going to be affected by the price pressures that this litigation is going to force on our companies. And there's a good article in the New York Times a couple of years ago that explained that the OPEC oil producers are sitting there waiting for the U.S. companies to start reducing their outputs so that they can then step and control a greater portion of the energy market. And they talked about, I think that OPEC would, at some point, would get up to like 75% of the international oil market. That's not good for our national security. It's not good for our energy security, but it's not good for climate change, because they don't have the same kind of commitment to trying to reduce emissions and try to do things in a more environmentally appropriate way as our companies do, and as we try to advance in this country. So we want to create a system that's going to work, that's going to produce the kind of innovation that Drew's talking about, without suffocating. Because you asked, is this going to make things worse? I think this makes things worse.
Okay.
Yeah, I think, look, litigation is not the answer to climate change. And to your point, does it make things worse? Yes, it makes things worse. There was a paper done 2023, London School of Economics did research on the impact of just filing a lawsuit against a company and the impact on its market cap. And then they also looked at the impact of if you're successful at that lawsuit. I'll use one example, ExxonMobil. So ExxonMobil has something like a $500 billion market cap, $500 billion. The impact is something like 0.5%. Now that sounds really small, right? 0.5%. It translates to about $3 billion if you're ExxonMobil. That's just one company, right? So that's just for filing a lawsuit. If they were then successful, it's 3 times that. So it goes from $3 billion to $9 billion of economic impact against the market cap of that company. Now, some would say, well, why do we care about the market cap? We actually want ExxonMobil to pay a price, right? Well, those are real dollars that investors, and in many cases, my dad, your grandmother, your parents, right, you yourself, have put money into a 401k that impacts your quality of life in the future. Those are also real dollars that those penalties flow through to consumers and force people to pay more for those products. And guess who is hurt worse by those impacts? It's lower and middle class people. Mm-hmm. So you're actually hurting lower and middle class people, not helping the climate, by imposing these litigious type strategies against these companies. And I would argue, why don't we move more towards incentivizing more innovation? There's a lot of money being spent around innovation. If you look at, I think it's been a couple of studies out there, something like $4.7 trillion of global opportunity for solving climate between now every year and 2030. That's a huge market opportunity to go out and find ways of solving these things. So, I feel like some of these sort of, climate litigators, I sort of feel like they're not all that different from the kids that like to throw paint on a painting in a museum. In this case, they're just throwing their legal paint against these companies in the hopes that it somehow makes things better.
Can I add one
Sure,
other
please.
thing, and that is there is a risk that it's a distraction, and a distraction that's counterproductive, and that is people start thinking that the courts will solve this problem, meaning that they don't have to be spending time thinking and putting their energy into finding solutions through other avenues, whether it be through the market or whether it be through through legislation or regulation. And so as a consequence, instead of throwing up your hands and saying, look, it's too hard and too expensive to get what we want done through legislative processes. Well, as I started out this conversation, that's intentional. But if you want to come up with good policy, you've got to win the policy debate, and you've got to be spending resources on thinking about the best way to accomplish that through both markets and the elected branches. And when people start thinking, oh, we can just trust the courts will solve this, then people aren't putting their attention where it should be in finding solutions in the appropriate places.
So on that point of efficiency, time, and energy, let me be devil's advocate for just a minute. If Congress wanted to preclude these type of lawsuits and act in an affirmative way, they could do that, right? They could pass a law that says can't sue on these things. They've done it before in different industries, but they haven't. So I think people on the other side will say, well, look, yeah, maybe you don't want to sue big oil, but either A, they are responsible, or B, we have to do this to keep pressure on them to decarbonize. What's your comeback? Is it that, well, they're great, that's policy, but it doesn't belong in the courts, it belongs up on Capitol Hill? Or how would you respond to that type of critique or criticism?
I'll start, but then I'm going to toss it to Phil because he's already introduced the answer to this, right? and that is that we should not presume that they haven't. In fact, that is what the Supreme Court currently has to consider, is whether or not indeed they have. Now, admittedly, they haven't done it in as clear a way as would make litigation unnecessary. The fact that they have not done it as clearly as they possibly could is the reason why the Supreme Court has to even decide this at all. But the AEP decision, in fact, said that Congress has displaced federal common law. That is, that the federal courts are incapable of developing common law for climate change lawsuits because we have entrusted the Clean Air Act and other avenues through the political branches to solve this. And so they have indeed preempted those claims. A sound reading of the AEP decision would be that that also extends to the preemption of state law claims, and it follows the same exact rationale that if the courts are allowed to do this, that they will be disrupting the ability for the legislature to not only decide what to regulate, but also, again, if you choose not to decide, you still have made a choice. This idea that there's part of when you don't regulate, it may very well be intentional, and the courts need to stay out of that and not be involved in perceived gap filling. The same exact rationale applies to these state lawsuits, and so the court has an opportunity to recognize that in the Hawaii case that you teed us up with early on, and so we may get a better answer to that in the coming future. But I know that Phil has dealt with this even more deeply.
Yeah, I mean, express preemption, as you're indicating, is kind of rare, but that doesn't mean you can sue over anything else in society. Sure. You have to actually articulate a lawsuit against somebody that they did something wrong, and in doing that wrong thing, that they've actually caused you an injury. Mm-hmm. And when we're dealing with public policy matters, you're getting far away from the idea of any kind of recognizable claim under common law, under statutory law. And so that's why a lot of these cases are being dismissed, because they're not stating a viable claim under recognizable law. Then you get the layer on top of that of preemption, of constitutional federalism, where you're dealing with what one state wants to say is legal in their state versus what another state does, and how all of that kind of fits together. But there are so many different avenues as to why these cases are not viable. And when you talk to people on the other side and you say, well, why then are you doing this? They say exactly what you just said. They said, well, all's fair in love, war, and climate change, right? That if we could do anything to advance the ball, if it puts any pressure on anybody to do anything, it's worth doing. And so that's their philosophy. We just think that the processes of our government and what the courts are intended to be used for and what's legislative, it is essential to our American lifestyle, and making sure that we protect what makes our country great. And that's why we just don't think you just throw all this legal spaghetti on the wall and see what sticks. You got to figure out what the right processes are to get what you're trying to do. And if you're not successful, doesn't mean you just throw more spaghetti somewhere else.
And the perversion of our court system, will work to the detriment of all interests, no matter where you are on the political spectrum. So there's just a failure to respect the limits of the courts, and also to recognize that if you start allowing courts to make policy that's favorable to you, you are empowering courts to make policy that's unfavorable to you. you are taking away your voice in the normal processes by doing so. And I don't think that message gets through, that you don't want to feed the, to borrow Ronald Reagan's line, right? You don't want to feed the crocodile hoping he eats you last. And if you feed the crocodile of judicial activism, there's very well maybe that crocodile comes back at you.
That's actually very wise, and I'm sure you all have seen it in government. I've heard things like, "Oh, well, trust us. It's us doing this." And you have to say, "Well, yeah, but what if the shoe is on the other foot?" And I think that's part of the problem in D.C. is that there's a tit for tat. Once you open a door to something, it's impossible to close the door, and we've seen that with how the parties interact with each other, the civility. It's like the Hatfield and McCoys. It just keeps going. And so opening Pandora's box. I do talk a lot about energy security as a scholar here at Hudson. And just for the audience, energy security is defined as the availability and reliability of affordable energy. I boil it down, but that's, I think, about as simplest as you can make it. And some people are trying to add a fourth criteria, which is the acceptability, which is obviously a very subjective term, whereas the other three aspects of what constitutes energy security is not subjective at all. And we've certainly seen this, the effects of this type of stuff. Let me just digress for a second. In Europe, where the EU Commission just received a report today on lack of competitiveness in Europe and what Europe needs to do to fix itself, because its GDP, which used to be equivalent to the United States 20 years ago, is now being far outpaced. I think we're almost 40% above the Eurozone. And whereas the Eurozone had mirror companies of US tech companies, massive deindustrialization, and the bottom line is the beast. You've turned the beast loose, and the government is regulating from a zero tolerance risk perspective, and it's killing innovation. Its energy policies have killed the industrial base of Europe because of a lack of cost competitiveness with the United States and with China and other places. Europe can't compete. And I see similarities of us tracking down that road a little bit. And a lot of this comes back to what is affordable energy. And so, if indeed from the legal context, the goal is to force a quicker energy transition, we can look to other countries to see the billions or trillions that have been spent and where they stand. And by leveraging innovation, we've actually reduced greenhouse gas emissions more than people who have really spent a lot of money trying to decarbonize. And again, thanks to America's natural resources that we have, right? And we are moving forward. So how can we move forward in these lawsuits? Don't these lawsuits add the cost of doing business onto every good that's produced in America, to the societal cost for each and every one of us? Are they akin to hidden taxes that we don't see by pushing things that are either not quite ready or forcing us away from current government policies? How does this hurt all of us?
Yeah, can I touch on that? Because Phil talked about this earlier. I mean, how does it help the global climate if we make American energy more expensive when American energy is actually the cleanest energy in the world?
Because we have an EPA. China does not have an EPA. I mean, it sounds so simple to say, right? Because there is no EPA in Russia. There is no EPA in the BRICS plus country, or OPEC plus countries. Now, I would say next to us, maybe Norway does a pretty good job. There are some other countries that do a pretty good job.
Yeah.
But your point is nobody really can do it better, and most do it a lot worse.
Yeah, and look, we need to drive the cost of all forms of energy, especially the cleanest. We need to drive that cost down as fast as possible. And Bill Gates talks about this, that there's a green premium currently on clean energy. And so Bill Gates is not out there saying we need to make clean energy, or we need to make dirty energy, quote, dirty energy more expensive. He's saying we need to make clean energy less expensive. And you do that through innovation, you do it through competition, you do it by investing. And so, the alternative is, you mentioned Europe. I mean, what's happened in Europe, case in point, Germany. Germany is a perfect example of top-down bad climate policy, right? They came in and picked winners and losers. They decided no to coal, no to nuclear, yes to natural gas, but natural gas from Russia, that then opened up an opportunity for Putin to come in and invade Ukraine, and Germany was left with its hands tied. So that's a perfect example of bad climate policy. And when governments try and pick winners and losers, ultimately who loses most is the consumers. So you referenced the innovation and the natural resources that we have in the U.S. I mean, we have reduced greenhouse gas emissions in the United States faster than any other country in history by having access to clean, affordable natural gas. And that happened not because the government said so, but it happened because an entrepreneur went out and took risk to open up these resources with, I'll say, a little bit of money from the Department of Energy that actually was helping to help incentivize the R&D on some of these fracking technologies long before it was economic. But then for the longest time, you had an entrepreneur who was willing to take that risk. So, I think to your point about affordable, reliable, clean energy, we need more options, not less. And, CEO of a solar company, I'll tell you, solar's not going to solve all our problems, right? It's great in some places, not great in others. I want options. I want my 401k diversified. I want my energy sources diversified.
So we're talking about that energy mix and what's the appropriate mix. And you believe that mix will naturally change over time, but you can't mandate it. And science, what's the saying? Science eats policy for lunch only 7 days out of the week. Other thoughts on this? And let's open it up to questions.
I think Drew's hit on most of it, but if the United States producers are at a competitive disadvantage, that leads to dependence, which leads to a decline in energy security for the United States, and that can happen through poor policy choices. It can also happen when the courts start imposing costs that otherwise should not be imposed, and basically leapfrog the political processes by imposing those costs or imposing changes in behavior that are not seen as the appropriate balance that's made by the policy branches. And the other thing that I will just make an amplification on is this idea that innovation is dynamic. Innovation cannot be commanded. Identifying where you should spend resources or what kind of activities you should incentivize. Part of the reason about throwing money at it not being effective is because it's simply beyond the capacity of governments to identify who should be incentivized to do what, especially in a fast-changing environment. The market can provide those kinds of incentives. The market can allow for easy adaptability, but you start spending resources on technologies that are picking winners even in sort of the preferred space, right? You start picking winners in that category, you are necessarily not allowing those resources to dynamically shift around to go to better technologies and allow for things to move forward. So just the things that we've known from a long-standing economic understanding and just to pull in Hayek or others here, right? Planners plan. That's what they know how to do, but they don't know how to innovate, and they don't know what kinds of activities should be done at any particular time.
Okay. How about questions? You all have listened attentively. Questions? Yes, sir. If you would please say your name and organization and question.
Thank you. My name is Brian Riley, and I'm from the National Taxpayers Union. And thanks, Hudson, for hosting this event. I'm curious, what kinds of groups typically have standing to bring these kinds of suits? And are we talking about suits against private companies or also against government agencies or entities as well? Thank you.
It's interesting.
Thank you.
I was talking a little before about how the advocacy groups and the special interest groups that are behind this litigation are trying to drive this litigation for policy purposes, to regulate, to all the above, whatever they can do to kind of do anything, right? But the local governments who are actually the filing the lawsuits are disclaiming any of that. They're saying, oh no, we're not trying to do anything to do with regulating climate change. We just need money. And your organization put out a great report a few months back talking about, hey, there's actually money out there. There's $40-something billion that the federal government has made available to communities like Hoboken, like Baltimore, like Honolulu, like all these others, to say, if you need help mitigating climate impacts locally, we've got some money for you. We've got some infrastructure funds. And only about, a quarter have been allocated, and even like less than a few $100 million has been spent. And so that's the avenue through which those communities should be going, not bringing lawsuits that they don't have standing to bring, that they don't have a cause of action that is viable, that is trying to make policy decisions that are outside of what the judiciary can handle, or having them pick the winners and losers based on who they want to sue for their lawsuit. So that's I think the challenge, and I appreciate your organization for bringing that report to light, because it really did expose that if these entities, these local communities really did need help, there's a place to go.
But Phil, you're missing the key component here, right? Who doesn't get any money from those funds?
Oh, the trial lawyers.
The trial lawyers, yes. So there's very little incentive for the trial lawyers to be pushing that kind of avenue, but there's a very strong incentive for them to go knock on the door of the local municipality and say, we're willing to partner with you for a cut of the money that you're going to get. And so a significant amount of the money that would come out of these judgments would not be going to abatement activities inside the locality, even if we could control that, which is a questionable outcome that we know from the tobacco litigation, right? But even a large portion of that will go into the pockets of the attorneys. And so we see a real partnering here. And in fact, there are plenty of stories where the municipalities would not have done these lawsuits on their own, but instead they did it precisely because they got that knock on the door and said, we're willing to represent you. We have a great theory for you. There's some free money for you. Don't worry about going and getting these other pools of money. We'll get it for you here. Of course, we need some skin in the game if we're going to do that. So a lot of this, as much of the litigation complex is driven by the trial attorneys who are behind this. I mean, I think you're right to point out the idea that it's difficult to understand who really should have standing. I mean, I think that there's questionable standing on the part of both private individuals as well as some of the municipalities to bring these cases. There are huge traceability and causation problems, right? We could spend another 3 hours talking about just the justiciability hurdles that should not be met in these cases. Yet, if you can find a sympathetic court, which is the other thing we haven't yet talked about, is that it's not by accident that the most successful cases have been in certain states, and it is because you seek out the jurisdictions who have sympathetic judges who have a mentality where they do not believe that they have such limited authority, but that has significant impact for the entire nation and the entire globe, as we mentioned before, because they are issuing orders, or they're purporting to have the authority to issue orders that regulate the global economy, that regulates the entirety of policy throughout the globe, including at the federal level. And the last thing on your point, I guess just to clarify, we have sort of the suits that are being brought, because I think you said, who are they against? I mean, part of them are against the companies, and some of them are against the government. And so we see the same thing on the other side. We see some are private litigants bringing these cases, and sometimes it's government bringing the cases.
It is funny that in the government cases, the suits against the government is saying these are political issues,
right?
Not judicial. And then in the suits against the industry, the local government is saying, oh no, these are perfectly fine for the judiciary. So I guess it depends where you sit as to what your view on this is.
Yeah, and I think one other thing that, just to think about is the local governments are sometimes also usurping the authority of the state governments. And so you see some states who are very unhappy with their local governments going and doing this, when the state government really should have the authority to decide whether to bring these kinds of lawsuits. So there's a lot of rogue local governments out there that aren't favored by their states either.
Can I just propose, I think that on the question of standing, and again, I'm not a lawyer, but I suggest that these groups, in order to have standing to bring these lawsuits, should give up all forms of energy. because energy clearly has trade-offs. There's negative externalities and there's positive benefits. On net,
Yep.
there are far more positive benefits than negative. And so this idea that like 200 people have been so harmed by the fact that they've actually been using energy all their lives, I think for them to have standing, they frankly need to just abstain from all forms of energy.
Yeah, or I don't know that the defendants have ever done this, but bring a contributory negligence or comparative negligence claim against the plaintiffs who are undoubtedly contributing to the problem under the theories, at least as they're posited, because
That they drove to court.
yeah, they drove to, that they breathed, that they took a breath.
Yeah, well, you all have raised some really good issues, and these. I was thinking, in the legal world, we when you seek a friendly venue, we call that forum shopping, right? And there's different versions of it, but so these aspects aren't new, but what is new is the issue. What is new is the topic, right? And so with that, I wanted to see if anybody. We have time for one more question, and then I would propose closing remarks. And we'll be out of here on time. We have time for one more question. I see a lot of eager hands in the back. Anybody? Wow. You all must have answered all of the questions.
Can I say one thing while they're thinking of questions on
Yeah,
the forum
please.
shopping point? Because it is an endemic problem in our system that there's going to be forum shopping, and that's obviously a bigger conversation. But these cases are a little bit different in this, because even if you forum shop, say, on bringing a suit about a particular drug, and you could have an impact on the availability of that drug as a result of this, right? That's always going to be a side effect of any suit. The person still has to show that they belong in that court, et cetera, and the judgment's going to be about that wrong to that particular individual. Here you're saying, I'm going to go to the state of Maryland and get a decision which regulates and doesn't just say there's some wrong localized to this particular individual, but instead there's a wrong that's happening in the entirety of the climate, right? And so the reach of those cases means that the forum shopping here allows for a far higher level of control on the part of a single state court judge than any normal tort lawsuit.
It's a very good point. All right, well, seeing no further questions, closing thoughts. So, Donald, we'll start with you and walk it back this way.
I think that these are important cases to watch, and they are places where the plaintiffs in these cases are constantly innovating. So I expect the theories and the strategies to constantly shift no matter where the state of the law is, and we've seen that from moving to filing federal lawsuits until AEP, and then moving to state lawsuits, but then state lawsuits claiming federal claims weren't working, so they've moved to state lawsuits claiming entirely state claims. So you should never expect that anything but innovation from the folks bringing these lawsuits, and for that reason, the courts need to be very, very clear as to why these suits do not belong, period. So that you're closing out avenues across the board, and you're shifting resources into markets and shifting resources into the political branches where they belong. But courts do not have the luxury of being vague in their determinations on these issues, because it will only encourage ways to circumvent those rulings.
All right, thank you.
When we talk about innovation as the way to get out of climate change, it's not the litigation innovation that you're talking about. It's the technology innovation that Drew's been discussing. And that's where I think we need to be making sure that we're focusing our policies and all of that on. Creating innovative ways to sue is not going to help. It's not going to help us deal with the meaningful issues that we need to deal with on climate. And so for those of us who really care about this and want to see things done the right way, that's the way I think we should be focusing our energies.
Okay. Drew, final word.
Yeah, I mean, I agree with my colleagues here, and I think, back to my point about free economies or clean economies, when we talk about economic freedom, what does that mean? It means lower regulation. It doesn't mean no regulation. It means lower efficient regulation that actually, regulations actually result in their intended outcome, right? It means lower taxes. It means governments that are actually efficient and effective at what they're supposed to be doing and not creating a lot of havoc in all other areas. It means a judicial system that can't be, gamed by ambulance chasers. So, I think this idea that if you're really serious about climate change and solving this in a generation, and we are, then we really need more economic freedom around the world. We need countries that are hungry for prosperity to be able to develop in ways that are economically free, environmentally free, politically, sustainable.
Yeah.
So these are really important, serious issues, and this idea that somehow, oftentimes, frankly, on the left, that you're only serious if you're willing to tax it or litigate against it. Well, no, that's the wrong approach.
Okay. Well, a big thank you to all three of you for coming. If we can have a round of applause for the panel members. Really appreciate that. And this will conclude our panel discussion. Thank you all for attending. Thank you all for watching online. And for more information on this or other topics, be sure to go to hudson.org. Thank you.